Good afternoon, and welcome to the final session of the 2025 ACS National Convention Series. I'm Zanelle October, Interim President of ACS, the nation's leading progressive legal network with over 200 student and lawyer chapters in almost every state and law school around the country. I want to take this opportunity to thank our sponsors for making the convention series and other ACS programming possible. I also want to thank the ACS staff, whose hard work and dedication are reflected in the success of this convention series and all the great work that ACS does. Over the past 4 weeks, this National Convention Series has offered an array of programming for members of our network and our friends. We've examined some of the most pressing legal issues facing our country, often as those issues took center stage in courthouses and communities across the nation. We've examined what can and is being done at the state and local level in the face of unprecedented abuses of power. We've featured advocates, elected officials, and public servants who provided the context and the on-the-ground view to understand the threats we are facing in areas like voting and elections, the rights of transgender people, economic justice, and in today's session, immigration. For the first time, we've offered attendees the chance to have more interactive personal conversations with some of our featured panelists through our talkbacks, which resulted in some of the most meaningful and impactful exchanges of the past 4 weeks. We've hosted virtual networking events for lawyers and law students, as well as successful in-person reception here in DC last week, where we were able to come together to find comfort, solidarity, and inspiration from our friends and allies in the progressive movement. As the National Convention Series comes to a close, I want to thank all of you who have attended these panels, the talkbacks, and the networking events. Each week, the Convention Series has sought to empower each and every one of you to find your voice, find your community, and help us find solutions to the challenges we face through engagement with allies in your own community, including with ACS's many student and lawyer chapters. Though this convention is ending this afternoon after this panel, the work that ACS and our members are doing to protect our democracy, restore and revitalize our Constitution, and work toward our vision of a law that improves the lives of all people will continue and will grow. And we want you to join us in this important work. If you aren't already, I encourage you to become a member of ACS and to donate today. Our work is more important now than ever, and we need your support. Please go to our website, acslaw.org, to join, donate, and find more information about events like this one. If you're already a member, consider becoming more active in your local chapter by suggesting programming or joining your chapter's board. And if you're in Washington State, Austin, Dallas, or Houston, Texas, or Virginia, our local lawyer chapters are looking for new members to join their boards and amplify their impact. Please join them. You can learn more about these opportunities, as well as volunteer and pro bono opportunities and opportunities to contribute to the ACS blog or our bi-weekly podcast by visiting our website or emailing us at info@acslaw.org. There's so much work to be done that it can sometimes feel overwhelming, but ACS's strength is in our network. Our strength is you. And I hope that you find strength in this network and the progressive lawyers and law students ACS brings together in your community and across the country. And now, it's my extreme pleasure to turn things over to our moderator for this afternoon's panel, Senior Reporter for Injustice Watch, Aura Bogado. I turn it to you.
Good afternoon, everyone. I'd like to welcome you to Then They Came for Me, Protecting Our Neighbors and Ourselves, a panel here at the ACS 2025 National Convention. My name is Aura Bogado, and I'll be moderating today's conversation with our amazing guests. Before we get started, to receive CLE for this program, you will need to submit 2 codes, which I'll provide during the program, once now at the beginning and once in the middle. Please write down these codes. You will need to enter these codes into the Google form that is available on the ACS convention page under the CLE tab. If you need help with CLE, you can email convention@acslaw.org. The first CLE code is Labrador. So as Zanelle said, I'm an investigative reporter, and I've reported on immigration through several administrations. And while I've sometimes struggled in the past to keep up with various policies and practices, this Trump administration's actions and the legal and activist responses to it feel like a whirlwind. Today's panelists are the people behind some of the most crucial immigration cases and related organizing for decades, and most importantly, in the last several months. Let me introduce you to them. Cecilia Wang is the National Legal Director of American Civil Liberties Union. She is a past director of the ACLU's Center for Democracy and ACLU Immigrants' Rights Project. She was previously a trial attorney in the Federal Public Defender Office for the Southern District of New York and served on the Federal Criminal Justice Act Indigent Defense Panel for the Northern District of California. Cecilia is a 1995 graduate of Yale Law School and clerked for U.S. Supreme Court Justices Harry Blackmun and Stephen Breyer. Washington State Attorney General Nick Brown is a proud product of public schools and son of public servants. He graduated from Morehouse and Harvard Law. He began his legal career in the Army JAG Corps, earning a Bronze Star in 2005. After returning to Washington, Nick worked as a prosecutor, then led counsel for Governor Jay Inslee, helping put a moratorium on the death penalty and challenging Trump's early actions. President Biden nominated him as U.S. Attorney for Western Washington in 2021, where he served before resigning in 2023 to seek the office of Attorney General. As AG, Nick focuses on protecting public safety, advancing environmental and worker protections, and standing up for civil rights. Alina Das is a professor, immigrant rights attorney, and co-director of the Immigrant Rights Clinic at New York University School of Law. For the past 2 decades, she's defended the rights of immigrants facing detention and deportation, including activists and leaders of the immigrant rights movement. She specializes in litigation and advocacy at the intersection of U.S. immigration and criminal legal systems. Her legal scholarship has been published by leading law journals and cited by the U.S. Supreme Court. She's the author of No Justice in the Shadows, How America Criminalizes Immigrants. She clerked for the Honorable Kermit B. Lopez of the U.S. Court of Appeals for the First Circuit and is a graduate of Harvard University, NYU Wagner School of Public Service, and NYU School of Law. And while he may be running late because of unfortunate internet problems that we all face from time to time, we will hopefully also have with us today Murad Awawdeh. He's the son of Palestinian immigrants who's dedicated over 2 decades fighting for low-income communities of color. As president and CEO of the New York Immigration Coalition, he leads the nation's oldest and largest immigrant rights organization. Through his work, he successfully expanded rights and protections for New Yorkers and delivered over $10 billion in community reinvestment. He's worked to welcome tens of thousands of recent arrivals, advocate for their needs, and strengthen the ecosystem of community organizations serving immigrant communities. Murad has successfully led electoral, legislative, and policy campaigns at federal, state, and local levels, and mobilized hundreds of thousands of New Yorkers at demonstrations against anti-immigrant policies. So let's get right into it. Alina, I'd like to begin with you. The title of this panel is Then They Came for Me, Protecting Our Neighbors and Ourselves. First of course, they came for your client, Mahmoud Khalil. He was just released a few days ago on Friday, and I want to talk to you about retaliation against protesters in general. But to start, this has been a long case fought in various venues, including immigration court, federal court, and of course, the court of public opinion. We also know that this case is far from over. Can you share with us some of the lessons about your client's case so far and this victory of Mahmoud's release?
Of course, and thank you all, and thanks to everybody who's part of organizing this event. This conversation actually would be very different had we not just had the bail hearing and release decision in Mahmoud's case on Friday. When we first actually talked about what we'd cover in this panel, at that point in time, it was not at all clear to anyone involved in his case that he would be released. And so, as he said the day that he was released, they picked the wrong person for this. He's certainly a fighter and had a whole team willing to come to him in a community that was fighting for him. But as he also said, that doesn't mean that there is a right person for this. And I think that's overall the lesson to be learned from what the government has tried to do. So to back up, for those of you who may not have known about all of the details of this case, we did see on the campaign trail that now President Trump had been promising to go after campus protesters using the kind of heavy-handed threats that we've seen candidates use over time, and taking this issue and making it into an immigration issue. And so that's what we saw be realized both through executive orders that laid the groundwork for trying to go after protesters. And with Mahmoud's case, he was the first to be arrested and detained in his home as he and his wife were coming back from an iftar dinner during the month of Ramadan. His wife at the time was 8 months pregnant, and they were looking forward to all of the things that expecting parents are looking forward to. And yet he was surrounded by unidentified men who were there with guns to take him away. And even as he and his wife exercised every right, exemplified everything that we teach in Know Your Rights presentations to do, they recorded what was happening. His wife was able to contact an attorney that worked for him. They asked for identification. They asked to see a warrant. They did everything they could to document what was happening. He was still ultimately disappeared for more than 30 hours without giving anyone the opportunity to know where he was, as they tried to transfer him, and did ultimately transfer him to an immigration jail in Louisiana. And what we do know from that moment is that because of the powerful community organizing that he himself has done and his wife, there was a community ready to support him. And that community also involved lawyers who were able to step in right away. Amy Greer and Kyle Barron filed a habeas petition at 4:40 in the morning in order to set this case in motion. And then an entire team, including many partners, including the ACLU and CCR and many other organizations, came together, CUNY Clear, to fight this in the courts. And it was a long, hard-fought battle that is still ongoing. But the important thing to know is that fundamentally, no matter how confusing the government has made it by trying to rely on arcane laws, in this case, a foreign policy ground that has its origins in the 1950s, to use that to go after people in the US who are just exercising their First Amendment rights to speak out about matters of pressing public concern. They try to rely on all of these old and confusing laws to justify their actions. At the end of the day, this is a very simple case. It's about our First Amendment rights and about the importance of protecting everybody's right to speak out without fear of being jailed. And so we are thrilled that after such a long fight, Mahmoud is finally here, able to be back with his family. He was taken away and was not able to be there for the birth of his son. But now he's enjoying those moments of parenthood that we all look forward to. And he looks forward to continuing to advocate, which is his First Amendment right. And we will have to continue to fight against the government's attempts to deport him in court.
Thank you. Just particular smile on your head. First, there obviously see you now on this other side as the case continues. Murad, I'd like to speak with you about your perspective from the ground in immigrant communities. Enforcement is nonstop. There doesn't seem to be any place where immigrants feel safe, not in schools, not in courts, not in work, not even walking down the street. Can you talk with us about how this enforcement is being felt by everyday people?
Well, first, thank you for having me, and apologies. We have a heat wave in New York, and our internet is in and out, but I think it's working right now because I'm on a separate internet line that we have here. But thank you all for having me. What we're seeing across the state of New York is really, saying an attack is an understatement. It really does feel like they're waging war against immigrants in New York City, New York State, and across the country. What we saw immediately after inauguration is the Trump administration really removed the shackles and the safeguards and the protections that were put in place, that our communities then became a prime target for ICE and Border Patrol to start operating in even more roguer fashion than they have in the past. We saw within 2 days over 140 dairy workers on farms in upstate New York, plus some hatchery farm workers, picked up in the span of 8 hours, which we had never seen happen in that short of a period, and it being so targeted. We've also seen some bad business owners calling immigration enforcement on some of their employees who are organizing their employees against the bad employer and having them be targeted that way. All the way down to seeing people really fearful of sending their kids to school because they saw something that resembled ICE in the streets. Seeing ICE in the streets of New York City is not an unusual thing, but seeing them at the level that people have has become incredibly frightening. And also what we're seeing in the courts, right? Where people are showing up to their immigration court proceedings or their ICE check-ins. And when you get off the elevator, and I encourage anyone who's in New York to go visit 26 Federal Plaza or 290 Broadway and go to the immigration floors and see how they are operating. You will see a dozen to 2 dozen military dressed law enforcement officers with masks covering their faces, at times sunglasses so you don't see their eyes, wearing hats, carrying M16s and other firearms with them, literally preying on our community members, those with attorneys and those without attorneys. And this has been in the news. People have seen it. We just had our New York City comptroller get arrested in trying to escort someone out of court last week. 2 people were actually detained that day while he was there within the span of 10 minutes. And we were seeing dozens of people per day getting picked up through the courts every single day. People who are following the process, right? People who are going to court. This is why when people say, do it the right way, we all know that it's BS, because even when people do it the right way, you're still entrapping them. And the way that ICE is operating in this moment is that they are tricking people. They are entrapping people. They are snatching them and disappearing them. That is what they're doing. And they're making it even harder for their lawyers to actually track someone when they do get detained. We are working on a case right now where a man was detained for a long period of time at 26 Federal Plaza, which is not a detention facility for those who don't know. And we've tried to bring 4 different congressional members to do an inspection of the 10th floor of 26 Federal Plaza, which is being used as a detention facility. And they've been refused access by ICE. And he was there for a prolonged period of time, wasn't able to take a shower, really horrible conditions for the people who were held there, HVAC issues, food issues, everything of the sort. He became incredibly ill. They moved him to Texas. And we have been having a very hard time trying to track him down in this moment. Thankfully, after we've escalated it, we have now found him in a hospital, and we are going to continue to fight for him. But these are the things that are happening. So the feeling on the ground is reflective of that, right? And we're trying to empower our community as best as we can. We don't have all the resources in the world to make sure everyone gets an attorney, but we're trying to make sure that people do have that. But also empowering them with information, knowing your rights. That has probably been the most successful tactic of community education. And I know it hasn't worked for everyone, generally speaking, but it has been an incredibly powerful tool to make sure that people who are home know what their rights are inside of their home, and making sure that people have the ability to exercise their rights.
Everyone, I'm the Senior Director of Policy and Program at ACS, and I'm just going to share Auda's question for AG Brown. You're a public official whose role has both protected rights and the rule of law in both Trump administrations, and protects the rights of people who live there against the violation of their rights by other actors within the state. Curious about how your office works with immigrant communities, and also want to know what it was like to challenge the Trump birthright citizenship order and be the first of those cases in which a court issued a ruling.
No, absolutely. And thank you everyone for inviting me to participate today. And I'd like to invite Murad out to Seattle so you can enjoy 80 degrees rather than 100-degree weather out here on the West Coast. Let me just say, being in this position as Attorney General, we get an immense opportunity to represent our state and also defend the rights and liberties of everyone within our states. And there is perhaps no more pressing issue right now than working to protect the rights of our undocumented community members here in our state who are by law entitled to due process and civil rights protections and the host of other legal protections, regardless of their status. And so our ability to work and to defend these rights really depends on our relationship with immigrant communities and the advocacy groups that work to support them, because our litigation, like any other litigation, is only as strong and as powerful as our ability to tell the stories of the people that are impacted and harmed by an administration that disregards their rights and their liberties. And we have now filed 23 cases against the Trump administration in my 5.5 months as Attorney General. Needless to say, it's been a busy start to my tenure in this administration, but it is really important for attorney generals across the country to collaborate with each other on this very important issue, because at a time when so many people, I think, feel powerless and without really knowing how to intersect and act in this moment, it feels good to be in a position where we can bring cases to try to defend the rule of law and negate some of the harms that we're facing. So the very first lawsuit that we were able to file was challenging the Trump executive order on birthright citizenship. As everyone recalls, that was one of the very first executive orders that was signed his very first day in office. We were able to file a case the very next day with a handful of other states because of all the work that the team had been doing over the preceding year to anticipate and prepare legal theories and arguments and declarations necessary to bring those cases. And so to be able to turn that around in just 24 hours, I think really showed that my state and many other states were prepared to meet that moment. And we very quickly got an immediate relief from our district court here in Seattle, the temporary restraining order, and then subsequently a preliminary injunction. And to be in that courtroom and to hear Judge Kunauer, who is a Reagan-appointed judge, who has been on the bench for almost 40 years, to hear him say unequivocally that this was a brazen disregard of the law, clearly unconstitutional, to really press the Department of Justice, not only on the legal theories, but their own professional ethics in bringing a claim that he felt was so loose on the law, was really a powerful moment. And I think a real indication of how district court judges might be viewing these issues going forward. So we had a case with 3 other states. My colleagues in New Jersey led another coalition of attorney general states to bring a case in the District of Massachusetts. But we also saw other parties bring challenges to birthright citizenship, and all 4 of the cases get, essentially the same result. That issue is now, at least in part, in the United States Supreme Court. So my team and New Jersey and others were in the Supreme Court last month when the court was hearing arguments, really not necessarily about the substance of the issues around birthright citizenship, but about the use and propriety of nationwide injunctions. And why they chose this particular case to take up that issue, one may wonder. But we heard from the bench, at least 3 of the justices, beyond the sort of the procedural issues, get into their views about how it was blatantly unconstitutional what the administration has done. And I'm hopeful and optimistic that once they get to the substance of this issue, that the court will reaffirm that, if you're born in the United States, that under most circumstances you are a citizen, because that has been the law of the land and the precedent for generations now. But we obviously are facing a number of challenging cases, and how the court ultimately rules on this issue remains to be seen. But it was nice to be in this position, and we rely on our ability to tell the impacts of our immigrant communities because of our stakeholder work with them.
That's such important work. And Cecilia, I know you were at the Supreme Court for several of these arguments, and we've already touched on more individual cases, in particular executive orders. I wanted to step back and get a sense of just how much the immigration policy landscape has changed in the last 5 months and what opportunities that's presented for litigation. And I'd really like to hear about your work on the Alien Enemies Act litigation.
Sure. Thank you, Valerie, and thank you to my co-panelists. Picking up on what we've all been saying and kind of reflecting on the last 155 days of this second Trump administration, I think the through line is that in terms of both volume and substance, we are in the most extreme anti-immigrant phase of my professional life with respect to what the federal government and many states are doing on immigration and more broadly individual civil rights and civil liberties in the guise of immigration enforcement. So there are a few factors, I think, that combine to make this a dire situation. The first is that, as promised, the Trump administration is focusing on interior enforcement of immigration laws and not just cracking down on entries as they did during the first term in office. With the Muslim ban and the various bans on asylum applications at the southern border. And we know from working on cases against state and local agencies that have tried to do interior immigration enforcement in the past, that if you tell law enforcement officers to go and find undocumented immigrants, they will racially profile people and engage in a pattern of Fourth Amendment violations. And that's exactly what we are seeing widely reported around the country as ICE and CBP and other law enforcement agencies are trying to go after people they deem to be undocumented immigrants, or in some cases, just someone they want to deport. Second, that leads me to this point, there's even more focus on people who are lawfully in the United States. The Trump administration has been trying to deport people who are green card holders, people who are here on student visas, people who were granted parole to come into the United States and live in US communities while they are fighting a removal case. And now the Trump administration is going after those people and entire communities of immigrants, including those who previously had temporary protected status, like Venezuelans. A third factor that I think contributes to this really dire policy situation on the ground is that Trump's immigration policies in his second term are even more clearly part of a white nationalist agenda than they were in the first term. And we see this in his immediate attack on birthright citizenship in his executive order issued on Inauguration Day. Attorney General Brown alluded to the many, many cases, including the one led by the state of Washington, challenging that executive order. Trump made it clear from day one that he is attacking the basic principles of Reconstruction in our country and the second Reconstruction, meaning the civil rights movement. So this is not just about immigration. This is about the Trump administration and President Trump's disagreement with the basic fundamentals of Reconstruction, that the United States is a multiracial democracy. And finally, the thing that I think makes our policy environment and the actual lived reality of people on the ground around the country so dire is that unlike during the first Trump term, you see certain states actively pursuing anti-immigrant policies this time around. On the other side of the ledger of Attorney General Brown and other state officials who are fighting for civil rights, for the Constitution, and for immigrant communities who are being targeted, you see other states like Florida, Texas, and others who are passing anti-immigrant state laws that are clearly preempted under federal law. But you see these states trying to get into the business, again, of interior immigration enforcement in ways that are clearly unconstitutional. So the situation is dire, but I will say that there is a silver lining. to all of this, and it is this. The courts have really held steady as a check on abusive executive power, even in cases where the president is invoking national security as the impetus for his policy or his action. And this is an area where courts have historically backed off, held that claims challenging federal government policies are non-justiciable, or areas where they need to defer to the judgments of the executive branch. But you really see that courts are holding steady against the worst abuses of the Trump administration, including in our litigation challenging his invocation of the Alien Enemies Act, a wartime authority to deport Venezuelans on his proclamation that not the country of Venezuela, but a criminal gang, Tren de Aragua, is mounting a predatory incursion on the United States, and therefore he can, on his own say-so, designate Venezuelan nationals for deportation under this wartime authority and send them not only out of the country, but to a gulag in El Salvador. And you've seen the Supreme Court twice now on its emergency docket in our litigation, first in a case called JGG, and then in a case called AARP. The Supreme Court has said in its orders in its stay docket that these are justiciable claims, that people do have a due process right to file habeas petitions to challenge a designation under the Alien Enemies Act case designations. And we'll see how that plays out on the merits. But so far, the Supreme Court has held steady on the basic due process principles. And I'll just end by saying that we have filed 64 cases, not limited to immigration cases, but 64 cases in total challenging second-term Trump policies. 48 of those 64 cases are immigration cases. And in those cases, we've sought injunctive relief in about 53 of those cases and have won some kind of favorable court order in over 70% of the cases where we've tried. So I think that should give people some hope. When I talk to people around the country, I think there's a lot of frustration, a lot of hopelessness, a lot of feeling that we have a federal government and many state governments that don't care about constitutional rights and that are targeting people unfairly and in a discriminatory way. And I would say that we should in fact be hopeful, because all of our resistance, whether it's through lawsuits or through protest, through peaceful protest, are working. And they are checking some of his worst abuses. And I say that still acknowledging how deep and how broad the harms are from this administration's policies.
Thank you, Cecilia, and my apologies for my own internet troubles. I think here in LA as well as New York. I don't know what's happening today, but thank you so much. And again, to receive CLE for this program, you will need to submit 2 codes, which I'll be providing during this program. I provided one at the beginning and now in the middle. Please write down these codes. You will enter these codes into the Google form that is also available on the ACS convention page under the CLE tab. If you need help with CLE, you can email convention@acslaw.org. The second CLE code is PUG. Murad, returning to you, I wanted to hear from you about TPS holders. I know we've heard a bit now. We just heard from Cecilia. Here are people who were explicitly granted the right to be in the United States and saw that right unilaterally pulled back by the Trump administration. We heard from you earlier about the ways that everyday people, immigrants, immigrant communities are feeling the tremendous focus on enforcement. Wondering if you can share with us what it's been like for people who did have a right to be here and had that rug pulled out from under them from one day to the next.
It's been, I mentioned this earlier in my comments, that this administration is really trying to attack in every single way, shape, and form our communities across this country. who are really the backbone of it. So it really doesn't make very much sense, the attacks that they're waging, when it comes down to it, right? Every wave of immigration to this country has provided the necessary power to move it into the future to where we are today. And the immigrant community is going to be needed to power the United States into the future again. So this is all backwards rationale that they're using. But what they are doing specifically is going after all immigrants regardless of your status. And we said that before when they, detained Mahmoud Khalil, who's a green card holder, and used I can't curse here, but they used not so strategic, or even what the judge also said seemed very unconstitutional parameters to do so. It was a way of punishing him specifically for him exercising his First Amendment right? So the attacks that we're seeing are not just on people who are undocumented. And just to be clear, I think that everyone should have a fighting chance and a right to be in the United States and be provided with a pathway to stay in the United States. The last time we've had any real immigration reform in this country was under the radical and extremely socialist President Ronald Reagan, who passed amnesty in the late 80s, which is sad. We have not done anything since then. And if we have, we've just criminalized aspects of immigration. So what we have seen, specifically to answer your question directly, is that we have seen not just temporary protected status being rescinded and canceled, which is going to impact nearly 1 million people who had legal status, be it temporary, but some communities have had temporary protected status for decades at this point. And that's going to unfortunately go away. What we're also seeing is not just with TPS, but we see it with humanitarian parole for the Cuban, Haitian, Nicaraguan, and Venezuelan program, where 500,000 people overnight lost their status. And they are waging this war against all immigrants, and they are trying to make as many immigrants undocumented as possible, because to them, they know that they believe that they will have an easier chance to sell to the public. Well, these people don't have any status. They don't belong here. But we all belong. And regardless of what era of immigration you look at, depending on who you speak to, they will tell you that it was the wrong way of coming here. And every wave of immigration has faced that, right? And if it weren't for the civil rights era and the movement of the civil rights, we would not have the diversity of immigrants in this country. We would not have a lot of the rollbacks that were necessary in that time to roll back racist policies. And we still see our immigration system being incredibly racist. So we have a lot of work to do. But I think it's important that when we're having these conversations, that we have them in jest, right? And we have them transparently. Many people may not have a pathway to relief right now, but that doesn't mean that they won't have a pathway to relief down the road, because something may change in their lives, and so on and so forth. So hope I answered your question.
Yeah, I think you did. Thank you so much. Alina, I want to return to you. We talked about lessons from Mahmoud's ongoing case. I want to step back and ask you about the very real stakes for everyone right now when it comes to free speech and the right to peaceably assemble. What are people potentially risking by literally expressing free speech, ostensibly protected under the First Amendment?
No, thank you for the question. So certainly I think everyone watched what happened to Mahmoud and then happened to other families in horror. And in addition to feeling the pain that was expressed and the anguish of his wife's voice as he was being taken away, I think all of us immediately thought of our own families, and whether something we say, a statement we signed, a protest we attended, a view that we've expressed, heartfelt and based on our experiences, whether any of those things could suddenly become cause for someone we love facing a similar situation. And that chilling effect is real. In addition to being an attorney, I'm a professor. I work at an institution filled with students and faculty who are there to learn from and debate others on all sorts of issues, many of which are critical of this administration. And the kinds of questions that they come to me with, that they're wondering if it's okay for them to write an op-ed. Is it okay for them to travel outside of the US to visit a dying relative? The choices that they're forced to make because of this fear, the chilling effect couldn't be more real. And I think that that is something that is a horrific reality, a harm that continues to live on. And that is why all of the efforts that Mahmoud and other immigrants who have faced this have put in to fighting back are so important, because we not only have to show in these individual cases that what happened was wrong, but we have to stand up for the First Amendment rights of immigrants and for all people. And that's particularly important because I think with all issues, immigration always creates this kind of exceptionalism in the law. I can't tell you how many people have said to me, wait, do immigrants have First Amendment rights? Questions that have been settled in many ways for a very long time in the courts, but they come up again and again because you have the administration pointing to their tremendous power over immigrants, that they have so much discretion. And that is also true in the law. The law has been used in both ways to hurt and to help. But ultimately, what we need to do is really normalize immigrants within the sphere of our constitutional rights, because under the First Amendment, it doesn't matter if the federal government has broad discretion over immigrants. The First Amendment forbids the government from using that discretion to punish or silence immigrants based on their speech, period, full stop. So once we really can adopt and embrace that right fully, yes, it's true. People have rights. That doesn't mean they're going to be respected, but you have to start by having those rights and exercising them, and then defending them when they get challenged so that we don't cede that ground even further. And I think another piece of this that's important is that the First Amendment isn't just about people speaking out. It's really also about our ability to listen. It's about the government not getting to decide what kind of speech people get to hear. And it's about we, the people, deciding for ourselves what we think is right and wrong. And you can only do that if everyone on all sides of an issue is able to speak out. So when we protect our neighbors, regardless of their immigration status and their ability to speak out, we're really protecting our democracy. And that's a lesson that has to be critical as we see retaliation being used as like the main tool by this government across all sorts of people on all sorts of issues, that it is just not okay for the government to exercise that kind of control over us.
Thank you, Alina. AG Brown, I want to return to you. You're in Washington, which boasts the Keep Washington Working Act. Adams County Sheriff Dale Wagner allegedly shared data about immigrants with the federal government and allegedly detained people based on their immigration status. Can you talk with us about why the Keep Washington Working Act is so important for you in your state and what enforcing the act really means?
Sure. No, thank you. And, this question is appropriate because a lot of this conversation is focused on the attacks from the administration on individuals and the broader immigrant community, which I think is the first priority and sort of thing we should be talking about. But what the administration is also doing is targeting states and local jurisdictions for their local state sovereign policies, many around redefining and reaffirming the distinction between federal immigration enforcement and state authority. And we've seen aggressive approach from the administration to not only critique and attack states because of their immigration-friendly laws, but also threats and actions to defund programs in states because of our support for undocumented people. And we in Washington are certainly facing that. So Washington has a law that was passed in 2019. It's called the Keep Washington Working Act. It is very similar to laws that exist in other states, but it is Washington's version of what gets framed as a sanctuary state policy. I try to avoid that term because it's not really defined anywhere in our law or nationally, but it is a law that was passed by the legislature to make sure that state and local officials do not get into the lane of federal criminal immigration enforcement. And so we have prohibitions on a number of different types of actors about the types of information that they can share with law enforcement, the types of assistance that they can provide to federal law enforcement around immigration enforcement. And that's what the Keep Washington Working Act is. And so since its passage, the AG's office was tasked by our state legislature to develop model policies for a number of different types of institutions, law enforcement being one, healthcare officials, school officials, and the like. We developed those model policies, and over time have tried to help local jurisdictions ensure compliance with state law. So we have often been in the position of reviewing model policies from local law enforcement divisions. To the extent we were finding instances where they weren't following the law as they should, we would work with them to come in compliance, to adjust their model policies and the like. And for years, that has worked fairly collaboratively. But what we saw in Adams County, which is a fairly rural jurisdiction in eastern Washington, is that our efforts to work with them collaboratively to get them into compliance with state law was not going particularly well over the last year. They sort of indicated that they would come into compliance, but then chose not to. And then right after the election of President Trump in this past November, they hired the law firm that was run by Stephen Miller, and essentially put their local county council to the side and hired Stephen Miller, and he kind of speaks for himself. So I made the difficult decision early on in my tenure to bring a civil case against the Adams County Sheriff and the county itself for failure to follow state law. And this is really important for me, and I think there are lots of fair debates that people can have around how we should do immigration enforcement in this country, the extent to which the feds should take certain actions or not. But my job, first and foremost, is to make sure that state actors follow state law. And what we had seen in the Adams County Sheriff, as our complaint in court alleges, is that they were explicitly violating state law provisions that prohibited them from communicating with ICE around criminal immigration enforcement. But Adams County was not only communicating, but they were transporting undocumented people into federal custody, and a host of allegations. And that's why we felt it was necessary to bring that case to reaffirm not only to Adams County, but to the entire state and to our entire population that there are limits about what state actors can and cannot do. That case is early on in the litigation. I feel pretty confident that our courts will reaffirm that there are limitations. We believe it's fully consistent with state and federal law, despite the threats and allegations from the Trump administration. And, related to that, we have been working really closely with our agency clients in dealing with the threats that they are facing to cut their funding because of immigration enforcement. There are probably two main categories of threats coming in to cut funding from the federal administration here. It's one, for our immigration-friendly policies, and two, because we still support and defend the lawfulness of DEI programs in Washington. And those two things have put a real target on our back, but we feel really confident not only in the law, but the philosophy and the principles and the policy behind those laws.
Thank you so much, AG Brown. For the audience, I'm sure that you've heard a lot of intriguing information. These are amazing guests. To submit a question, please use the Q&A box at the bottom of the Zoom screen. Do not use the chat to ask your questions, as we will not be monitoring the chat for this, and your question will not be put in the queue. If you're a member of the press, please include the name of your outlet at the beginning of your questions. Thank you so much. Cecilia, back to you. Something that's felt very confusing, I know, for me as a reporter and for lay people, but I imagine also for attorneys as well, is when an administration doesn't follow a clear order from the court. I'm curious what it means to win a legal victory only to have it ignored by the federal government.
So I think we are really seeing the president testing the limits on this issue of whether he needs to comply with court orders. And we've seen in at least two high-profile cases, situations where the administration effectively didn't comply with a court order, even while they also went into court to continue to raise legal arguments on appeal in disagreeing with the court order. So the first of these cases is an ACLU case, JGG. This is one of our Alien Enemies Act cases I mentioned earlier. And in this case, what happened was we initially filed the case, the complaint, and an application for a temporary restraining order when we caught wind of the fact that Trump was going to issue this proclamation declaring that Venezuelans in the US are members of this gang, and that therefore he could invoke the power under the Alien Enemies Act to deport them without any process. And on the very next day, it was Saturday, March 15th, the district court first issued a temporary restraining order in the morning, and then during a hearing in the evening, found out from the government lawyer who appeared in front of him that there were 2 planes that were in the air carrying Venezuelan nationals who the president was deporting using the AEA to El Salvador to be detained in the CCOT gulag. And the district judge ordered very clearly that any people who were in the air should be turned around, the plane should be turned around, and that they should be brought back to the United States. Well, it turns out that, in fact, the government did not comply with that order. And as we all just found out, along with the rest of the world, through the whistleblower complaint of Erez Ravini, who was one of the Justice Department lawyers in that case, a senior DOJ official, Emile Beauvais, countermanded, deliberately flouted, according to Erez Ravini's disclosure, the district court's order, and permitted those planes to continue on to El Salvador. As a result of that, at least 137 people were deported to CCOT in violation of the district court's order. There was actually a total of 261 people deported, but as to some of those people, the president said that he was deporting them not only under the AEA, but also under some other regular provision of immigration law. The second case in which we've seen the Trump administration directly flouting a court order was in the Abrego Garcia case, which is not an ACLU case. In that case, we all have followed along as for months, the Trump administration first refused to comply with the district court's order requiring them to effectuate the return of Mr. Abrego Garcia. But then kind of, again, we're testing the limits after the Supreme Court issued an order saying that the district court, maybe couldn't say that the Trump administration had to effectuate the return, but had to at least facilitate the return. And after that, you saw the president of the United States sitting in the Oval Office with the president of El Salvador, whom he had paid to detain these people who the U.S. had deported. And the two of them basically, with a wink and a nod, saying, oh, the president of the United States doesn't have the power to effectuate the return of people from El Salvador. And the president of El Salvador is saying, oh, well, I can't, send someone to the U.S. that the U.S. doesn't want. And then finally, of course, culminating in the announcement that perhaps in a face-saving gesture, the United States would return Mr. Abrego Garcia, but to stand to face criminal charges. So I think in these two cases, you see a couple of things that, if you give the Trump administration an inch, they will take a mile. That's what you see with the Abrego Garcia Supreme Court order, where the court said, we don't know that the courts have power to say effectuate the return, but the courts can say facilitate the return. And then you saw the Trump administration really pushing back and basically being recalcitrant. I think there's a troubling possibility as we see litigation in all of these cases continue with the Supreme Court's stay order in the DVD case this week. This was a lawsuit challenging the Trump administration's deportation of people to a third country, not their country of nationality, without any process. The regular immigration laws provide that if the United States is trying to deport someone not to their country of nationality, but to a different country, there has to be a process for that. And the Trump administration is bypassing that with their notorious and absolutely illegal effort to deport nationals of Mexico and Vietnam and Laos to South Sudan, where you have these people who are trapped in Djibouti. These are the plaintiffs in the DVD case. And as Justice Sotomayor, rightly called out in her dissental in that DVD stay decision, the Supreme Court is troublingly now not looking at one of the factors that the party moving for a stay has to prove, that they're harmed by the court order that they're trying to stay. And I think, we'll see if this pattern holds steady, but I think if the Supreme Court continues to issue orders like the DVD order, they're going to face a real erosion of public trust in the Supreme Court as an institution. And you're going to see the legitimacy of the court being eroded, where they don't hold the Trump administration to the same legal standards that other parties must meet in front of the Supreme Court. I think it will be a real disaster, not only for the outcomes of these particular lawsuits, but also for the broader functioning of our system of checks and balances in this country, if the Supreme Court starts pulling punches and not following its own rules and own precedents in granting this administration the relief that it's seeking. And I think that's something to really watch out for as we go forward. As I said, a few minutes ago, so far, the lower courts and the Supreme Court in the Alien Enemies Act cases, hopefully in the birthright citizenship case as well, will hold steady. But I think we really need to be watchful as constitutional lawyers as we see a lot of these other cases playing out, particularly on the Supreme Court's emergency docket.
So we've got about 15 minutes for Q&A. We've got really great questions in the chat. To follow up on what you've been talking about, Cecilia, I'm curious to hear from any panelists, but especially from Alina as well. Here's a question from an anonymous attendee who asks, how would you characterize, in your eyes, the inclination of the 6 justices on the Supreme Court who've ruled in favor of expanding executive power insofar as national security arguments that lower courts have negated?
Well, I think it's, as Cecilia was saying, I mean, this is the time where we need the checks and balances, and that there's no invocation of magic words that the executive can sprinkle into its legal papers that should let courts off the hook from actually applying constitutional principles. So, and we've seen this in the cases involving students and scholars who've been targeted, where the government's taken the position, look, this is a national security issue, and therefore, we don't even have to justify our actions. We can simply evoke certain words and present, a 1-page or 2-page document, and that should suffice. And lower courts have pressed back on those propositions, noting that you have to do more than simply say that foreign policy, national security is involved. But I think that goes back to the point that Cecilia was making. You do need courts to be willing to hold that line all the way up to the Supreme Court. And you need there to be, I think, a collective response when we hear and see the federal government taking these aggressive positions against judges. It is completely uncalled for how the administration has talked about judges who have issued very reasoned decisions. Sometimes, in many cases, not everything that we want. They make a decision based on their views, whether we agree or disagree. That does not make them into rogue judges. It doesn't make them, into people who are derelicting their duty. They're actually doing their job by holding the executive accountable. So every time we see a statement from the federal government, the executive branch, criticizing our court system, I think that just feeds into this question of legitimacy. And that's all the more reason why the Supreme Court, as the highest court of the land, really needs to do its job and at minimum explain many of these decisions on their shadow docket, or whether they're granting stays or allowing certain injunctions to take into effect or not. They're often giving very little explanation, and we're really hearing from the dissent the concerns that we all fear. So we need to have courts and to support our courts when they do take positions that is part of the process. And I will say that it goes down to individual cases. In Mahmoud Khalil's case, the same day the federal judge ordered his release, the immigration court judge ordered his deportation, even on the ground that the federal court judge had enjoined. His immigration counsel at Vanderholt Law Firm had been litigating that case and presented, the court's injunction on the foreign policy ground that the government had relied on, and the immigration judge ordered him deported on that ground anyway. And we are still waiting to hear from the federal government what their position is on that, because they had told the court that that his order was binding. So those are the kinds of concerns that are playing out on individual cases. They're playing out in some cases in the headlines, but they're also happening every day to people who don't necessarily have all of the resources and all of the eyes on their cases. So every time a judge, stands up for what they believe in, issues a reasoned decision, and is actually trying to apply the standards fairly, that's something that's incredibly important that we need now more than ever, given how far the executive is willing to go to break the rules.
And we've got more questions. Celia, I don't know if you wanted to answer this one as well, but if not, we've got some other really good ones.
Now let's move on to the next.
Okay, great. Murad, I was thinking about maybe posing this to you. Corey Amron asked earlier, can you talk briefly about what's happening to the children of deportees, especially those who do not have another parent or guardian to care for them? I'm wondering if you're seeing some of that.
We are, and we're hearing of different accounts of parents who are showing up to check-ins or immigration court without their kids and being asked to bring their kids with them so that they then can get detained together, which is horrific. What we're seeing is, in some cases where one parent is being detained, then the burden then falls on the other parent. We've been working with our membership across the state of New York to actually conduct family planning with our community members, which is, if, God forbid something were to happen to one of the parents, they're authorizing and executing their wishes of what to do in that case, right? Every state has different laws on what family planning could mean. It could be temporary guardianship over someone, or it can be, in the very unfortunate circumstances, potentially full guardianship over moving guardianship to someone else. So we're seeing some families who are doing the guardianship and parental planning, and others who really don't want to be separated from their children. So it's been a really difficult moment. There have been families who have been separated already, and that number continues to trigger upward. And what we're also seeing is, in some cases where families are checking in or going to immigration court, they are getting detained together. So people are trying to do what is best for them. And that is a decision that they make. We just provide the options that are available in the moment, and really try not to infer what is the better option. I think that this is a decision that the family has to make for themselves.
Thank you. Joel Gilman asked a question that I know I've heard a lot about. In news coverage of ICE raids, we see ICE officers wearing masks and not wearing clothing that identifies ICE, and using unmarked vehicles. Are ICE officers required by law to clearly identify themselves when questioning someone they suspect is in the U.S. illegally?
So again, I mentioned this earlier. I think that, quote unquote, right way, wrong way of getting here, the vast majority of people who are in the United States have overstayed their visa. So they came in the right way. They just overstood, and there hasn't been a pathway for them to adjust. So that's one thing I want to say. But we have to stop having these conversations about like the right way, the wrong way. It doesn't matter to the Trump administration. They are attacking all of our community members. They're trying to make the illusion that our community is in some way dangerous, as if they are not contributors, that they're leeches, that they are destroyers, not builders. That is not who we are. And our community has built this country and it will continue to do that. Here in the state of New York, about $81 billion of tax resources from local and state taxes that are contributed come from our communities who are documented and undocumented. Our spending power here in the state of New York is over $200 billion. I think we, can compete with other, countries' GDPs. So the reality that, people keep asking these questions of like, documented versus undocumented.
Right.
I think that's just not a relevant question anymore. It doesn't matter. They're making people undocumented. They're going after families. They're going after people who they said that they wouldn't go after, that they're going to go after the worst of offenders. And even the worst of offenders, I believe that they deserve due process. So I think that we have to move away from this really weird mentality of like saying who's worthy and who's not. We're all worthy. These are like tools and tactics of white supremacy. And I don't want to talk about that in this space, but that's what literally it is. And we're better than that. And we shouldn't be allowing tools of division to be sown and used in our communities, because our communities have consistently been under attack under all administrations. Yes, Biden did some great things, but also Biden did some horrible things that allowed for Trump to run the way he is right now with the policies that were put in place. So I don't think that any administration has been kind or good or has thanked our community the way that they should have over the past 38 years in this country. But we're going to continue to fight and build our power here in New York and across the country to finally deliver the justice that our communities deserve.
Cecilia, I'm wondering if we can hear from you on this question about whether or not ICE law enforcement officers are required to identify themselves.
Yeah. I believe ICE regulations provide that agents are supposed to identify themselves as soon as practicable. So the reg, I think, gives them a lot of leeway. Most law enforcement agencies do require by policy officers to identify themselves. And there are important reasons for that. I should say, by the way, that we are supporting legislation that would prohibit federal law enforcement agents from wearing masks or otherwise obscuring their identity as they're, going about their business. I think you're seeing some very troubling developments in the federal government's response to protests around that grow out of ICE raids and arrests, like in the Los Angeles area. And the reason that most law enforcement agencies require officers to identify themselves, to wear insignia that show, their badge number and their name, is because it's important for purposes of law enforcement that people understand when they're dealing with law enforcement. We're seeing reports of a lot of private vigilantism, and, people who are, buying, police vests or gear and going out and engaging in their own efforts to go and find undocumented immigrants. And so, the way that I think this would come up, even though ICE isn't required not to wear masks during, for example, immigration raids or in law enforcement responses to protests, is that, if I'm filing a civil action alleging that ICE agents and other federal officers used excessive force in a way that retaliated against people for exercising their First Amendment rights, which is a case the ACLU of Southern California has just filed, then it matters if the actual federal officers are out there wearing masks, if they're out there with their badge number taped over, if they're out there wearing unofficial insignia like the Black US flag, right? Especially in a context where you see a lot of private vigilantism if federal officers end up bringing criminal charges against someone, saying they assaulted a federal officer or they resisted arrest or obstructed justice, it matters if the officer was masked or was otherwise obscuring their identity or refused to identify themselves. And so it's not only important for the exercise of all of our First Amendment rights in the protest context, but also important from a law enforcement perspective that officers do not wear masks when they are patrolling during protests or in any other course of their duties.
Thank you so much. And thank you to all of our panelists. And thank you for all of you who are attending. Thank you for everyone who's participated and attended the 2025 ACS National Convention Series. For those of you who wish to talk more about the issues raised during today's panel discussion and with your fellow attendees, ACF staff, and some of our panelists, please stick around. You'll be randomly assigned to a breakout room for a more informal, and interactive conversation. The facilitator of your breakout room will provide more instructions when you arrive. Thank you so much.